To begin this evening on a thoughtful note, may I request everyone to kindly rise for a moment of silent prayer. Thank you. Please be seated.
Now, to formally welcome you all and set the tone for the evening, I invite Dr. Anil Joseph, Vice President and Program Chair, Kerala Management Association, to deliver the welcome address and introduce the speaker. Sir, the stage is yours.
Good evening, all. It's my privilege to welcome you all to today's KMA Leader Insight program on behalf of Kerala Management Association. I extend a warm welcome to our distinguished speaker for the evening, Advocate Dr. Joseph Abraham, our President Ajay Khalid, Joint Secretary Ramesh, past presidents of KMA, members of the Management Committee, my fellow program committee members, distinguished guests, and all participants present here this evening. Today's session, FCRA 2026, New Compliance for Corporates and NGOs, focus on a subject of immense significance and growing relevance. As the regulatory framework governing foreign contributions continues to evolve, compliance has become increasingly critical for NGOs, charitable trusts, educational institutions, CSR foundations, and corporates involved in social development initiatives. The recent amendments to the Foreign Contribution Regulation Act have introduced significant changes, including stricter provision relating to asset management, activity, and geographic specific registration for NGOs, and enhanced oversight through a government appointed designated authority. These reforms represent a major shift in the compliance landscape, demanding greater transparency, accountability, and governance from organizations receiving foreign contributions. At Kerala Management Association, one of our key objectives is to bring eminent experts to share practical knowledge on emerging issues that impact professionals and institutions. I am confident that today's session will provide valuable insights, clarify important legal developments, and help all of us to have better understanding in the changing compliance requirements under the FCRA framework. It is now my honor and privilege to introduce our distinguished speaker. Advocate Dr. Joseph Abraham is an advocate on record at the Supreme Court of India and one of the country's leading legal experts in civil, criminal, immigration, family, and service laws. He holds a PhD in migration laws and has devoted his career to advancing migration law, minority educational rights, and public legal awareness. He is the founder president of Pravasi Legal Cell, an internationally recognized organization working for the welfare of overseas Indians, and serves as the chairman of the Paideia Institute for Training and Research in Social Sciences, New Delhi. He is also the legal advisor to several NGOs and minority institutions in India and abroad. His remarkable contribution have earned him international recognition, including the prestigious IVLP Impact Award 2023 from the United States Department of State for his outstanding work in minority empowerment. Dr. Abraham has been instrumental in several landmark initiatives, including the abolition of the nurses' labor-bound system, facilitating the repatriation of immigrants' mortal remains, establishing an online RTI portal, and securing minority status for more than 7,000 educational institutions across the country. He has served as the secretary of the CBCI Committee on Law and Public Interest Litigation for 7 years and is currently the president of the Bar Association of the National Commission for Minority Educational Institution, New Delhi. An accomplished author, he has written several important books, including Indians and Immigration, Safe Immigration, Minority Rights, and Immigration and Foreigners Act. His scholarly contributions have been recognized by the Honorable Chief Justice of India. What makes Dr. Joseph Brown especially suited to address today's topic is his unique combination of legal scholarship, courtroom experience, policy advocacy, and extensive work with NGOs and institutions navigating regulatory and compliance issues. May I invite everyone to join me in welcoming Advocate Dr. Joseph Brown. Sir, we are honored by your presence and grateful that you have accepted our invitation. We look forward for your valuable insights. Thank you.
Thank you, sir, for that warm welcome and introduction. Next, it's my privilege to invite Mr. Aljays Khalid, President, Kerala Management Association, to deliver the presidential address. Sir, may I request you to address the gathering?
Good evening, everyone. I hope you all had good cup of tea and coffee before setting to listen to this important topic today, because what is coming next is worth staying alert for. We are here today for another one of our KMA Leader Insight sessions, and honestly, I think this is one of the most important and one of the most important ones we have done for a while. The topic, FCRA 2026, New Compliance for Corporate and NGOs, sounds a bit dry, isn't it? But trust me, by the time our speaker is done, you'll realize this affects almost everyone of us in this room. Whether you are running a company, sitting on the board of a trust, or are involved with any NGO work on the side, it is important for you. Now that our program committee chair and vice president, Dr. Anil Joseph, has already introduced our chief guest for the day formally, I just want to take a few minutes to add something, and I promise I will keep it light. To tell you that how I actually know today's chief guest, because this isn't one of those introductions, it's special. Advocate Dr. Jose Abraham and I own apartment in the same building on Cochin Marine Drive, and we are part of the Owners Association in the past for several years now, and know each other personally. And over that time, what started as just friendly hellos slowly turned into something more conversational that went on a little longer than what should have been. And I will tell you that that more I spoke with him, the more I realized this man actually knows his subject: civil law, criminal law, immigration law, service law. He moves between all these with an ease you don't see very often. It's one thing that to have a master's degree or a postdoctoral degree in law, and another thing entirely to have the kind of grasp that he has in his subject. In fact, I have personally gone to him for advice on few occasions myself. Nothing dramatic, just situations where you need someone with real clarity to tell you what actually is going on, not just what the rule book says. And every single time, he has given me something I could actually use. Not just legal theory, but practical, sensible guidance. That contributions, knowledge, that combination of knowledge plus practicality is honestly rare. I've met plenty of very knowledgeable lawyers in my times, and plenty of very practical ones, but rarely both in the same person. Among everyone I know in the legal fraternity, he's someone I genuinely respect, not as a formality, but because I mean it. So that's the personal side of it. Now let me tell you how this particular section came about. I happened to catch him speaking on this very topic, FCRA compliance, at another platform a few weeks ago. And I remember watching and thinking, this is exactly the kind of clarity our KMA members need to know. So I didn't wait. I reached out to him almost immediately and said, look, you have to come and address our members on this. And to his credit, he agreed without much persuasion. Now, why this topic and why him specifically? Well, if you have been following the news, FCRA compliance has become a serious concern for NGOs, obviously, but increasingly for corporates too, especially anyone dealing with foreign contributions, grants, CSR funding routed through foreign sources, or cross-border collaborations. The rules have tightened. The penalties for getting it wrong has gotten more serious. And frankly, most of us in this room are not lawyers. We run businesses, we manage organizations, and compliance is one of those things we rather get it done right in the first time than learn about it after a notice has landed on your table. And when it comes to immigration law and foreign contribution regulation specifically, Dr. Joseph Braham isn't just someone who has read up on the topic. He's an actual authority. His work on this multiple angles, he has worked on it multiple angles, academically with a PhD in migration laws, and practically through his work with the Pravasi legal cell and several other institutions. So when I say he's the best person to talk to us about this today, I'm not just being polite, I genuinely believe that. Now, I will stop talking soon, I promise about it. But before I do that, I wanted to tell something about Dr. Joseph Braham. I really don't want to stand here between you all and him. He's an eminent, and I might add, rather young and handsome lawyer who practices at the Supreme Court of India. And he's too young to be at the apex court, if you ask me, but rich with knowledge and experience. As all of you know, Supreme Court lawyers don't charge by the hour or even by the day they appear in the court. They charge by the minute. So every second he spends with us here, please sit back, is technically costing someone a fortune, which fortunately for us today is on the house. So every moment is precious. So let us not waste a single moment, one of those important moments. Sit back, listen closely, and I promise you will walk out of here today knowing a lot more than you did when you walked in. Ladies and gentlemen, please join me with a loud applause to welcome Advocate Dr. Joseph Braham onto the podium. It's all yours, sir.
Thank you, sir, for your inspiring words. And now the moment we have all been eagerly waiting for. It's my honor to invite our esteemed speaker for the evening, Advocate Dr. Joseph Abraham, AOR, Supreme Court of India, to deliver the keynote address on FCRA 2026, New Complaints for Corporates and NGOs. Sir, we are delighted to have you with us. The stage is yours.
Good evening, everyone. First of all, let me thank the organizers for having me here. I regularly follow the activities of Kerala Management Association for the last couple of years, and I am really happy to say that the kind of activities this organization is doing is really a role model for all the associations in Kerala and also in Ernakulam particular. And I would like to appreciate the organization for doing such a wonderful job, and I wish all the very best wishes to the new team headed by our beloved Algiers sir and I am sure that the Kerala Management Association will reach into the new heights, and this tenure would be a fruitful tenure. I wish all the very best wishes. And friends, FCRA is a hot topic. On 22nd of June 2026, there was a rule amendment published by the Ministry of Home Affairs, which was there in the news, and in the month of March, again, another amendment was published by the Ministry of Home Affairs with regard to some of the major provisions of the FCRA Act, and this was widely published, and there was a huge reporting in the media, and the civil society organizations were taking up that matter. And let us try to understand what was the changes which actually proposed this new amendment, which was came up in the month of March, and last week also the other amendment which was already notified by the Ministry of Home Affairs, Government of India. Yes, let us initially see what is the legislative overview of the FCRA in India. This act was introduced in India for the first time in the year 1976. As we are all aware, India was actually on an emergency mode in the year 1975, and the then government reasonably felt that the foreign authority or the foreign governments can influence the sovereignty, integrity, and the existence of this country by way of pumping money to this country, and to regulate and control all such activities. Originally, the act was introduced in India in the year 1976. Subsequently, this act there were some amendments in 1984, and even in 1990s, some minor amendments. But subsequently, in the year 2000 and 2010, the old act was completely repealed, and a new legislation was brought out. That is what is known as Foreign Contribution Regulation Act 2010. The present law, which is applicable for the time being, is the FCRA Act 2010. And in this act itself, there was a major amendment was carried out by the Parliament in the year 2020, and then subsequently a bill was proposed by the Parliament in the year in 2026 that was yet to be passed, and last week one major amendment was actually brought out by way of FCRA Amendment Rules 2026. So these are the legislative history as far as FCRA is concerned. Now let us see what are the objectives of this FCRA Act. It says that to regulate the acceptance and utilization of foreign contribution or foreign hospitality by certain individuals or associations and its utilization. So please note that this FCRA, Foreign Contribution Regulation Act, is applicable for certain associations, and also it is applicable for certain individuals. With regard to accepting any foreign contribution and its utility. That is what the whole concept of this FCRA, Foreign Contribution Regulation Act. And it says that no association is permitted to receive foreign fund without FCRA registration. It's very important. Without having a valid registration under FCRA, an association cannot accept any kind of foreign fund. So we will also see what are the associations and what are the legal entities permitted as per this FCRA. And then it again says that money received by individuals for professional service or part of business are not covered under FCRA. Please note that we are all professionals. You may be doing a lot of services to your foreign clients. Absolutely no bar. Whatever services which you are providing in your individual capacity and whatever remuneration, whatever return which you are getting, those aspects are not covered under the FCRA. So FCRA is actually applicable for all the donations which are received by the entities, the legal entities, and also by individuals. So there the role of FCRA would come. And again it says that foreign hospitality or prior permission from the MHA is required for members of legislature, judges, public servants, etc. Yes, if a government public servant, by way of his official capacity, he is absolutely not permitted to visit foreign countries without having proper permission. That is actually governed by the FCRA. Persons such as MLAs, MPs, ministers, or even judges, or the public servants, they are supposed to get permissions under this act for any kind of foreign hospitality to receive from abroad. That aspect is also covered under this legislation. Now let us see what is FCRA registration. Application for FCRA registration can be submitted by a society or a trust or a charitable company. That charitable company is also constituted as per Section 8 company as per the Companies Act 2013. So these are the three major entities. The law says that the associations which are majorly classified into three sections. One is a society, the second one is a trust, and the third one is a charitable company. Now let us see what is a society. I hope our KMA is also registered as a society, right? Yes. Society means a group of individuals who have a common objective to perform certain objectives as per this memorandum of association or articles of association can form a legal entity. That is what the definition of a society is concerned. So there are two kinds of society majorly. One is a state society and the other one is a national society. State society means a minimum of 7 members can form a state society, but for registering as a national society, minimum 9 members, and out of 9, 7 members should be from different states. That is what a national society is all about. National society can perform, their area of operation would be national throughout India. But as far as a state society is concerned, they can their area of operation that is limited within a state, or it can be restricted to a district or whatever it may be. Many of our residential welfare associations are registered as a society, and that objectives may be very, very limited. And that is what the one set of entities, that is societies. Now in Kerala also, we earlier we had a legislation known as Travancore Cochin Scientific Society and Literacy Registration Act 1955. Most of the associations may be registered as per that act only, but that also now repealed by the government of Kerala in 2025, and now we have a new legislation in the state of Kerala, even for registration of a society. So the new legislation in the state of Kerala for regulating the activities of societies are governed as per the Societies Registration Act 2025. And nationally, if we look at the aspect of nationally, Societies Registration Act 1860 is the major law, which is a central law, and the societies which are functioning on a national basis, which are actually covered as per the Societies Registration Act 1860. The second entity would be trust. What is a trust? Trust is it's a small kind of entity. Minimum 2 members can form a trust. One person who is designated as the author or the settler on one side, and on the other side he can nominate a person as a trustee, and accordingly they can form a trust for performing the objectives which are governed as per the deed of that particular trust. So that is what the second major entity. Trust is a very small kind of entity. Only minimum 2 members are the sufficient number. For a society, minimum we need 7 members for a state level society, and 9 members for a national society, and there is no maximum number. It's up to you. And a society would be having 3 documents such as a registration certificate. After registering, you will get a registration certificate, and there would be a memorandum of association which states about the objectives for which that entity is formed. If it is a residential welfare association, then it would be saying that the association is formed for the purpose of so and so objectives. But if it is a charitable society, or if it is a educational society, or it's a religious society, the objectives of that society would say for what purpose that entity is constituted. Similarly, a trust also would be having a trust deed, which categorically states about what are the objectives for which that entity is constituted. The third entity is charitable company. We know that, yeah, all the business people, our Kerala Management Association is also maybe consisting, most of our people are maybe part of some corporates. So basically the companies are formed for the purpose of generating income, or generating income and also for the purpose of profit. But all these FCRA thing would generally applicable for the non-profit organizations. So a charitable society, or a trust, or a charitable company, their prime objective is to they formed for the purpose of doing charitable activities, not for the purpose of making profit. So that is what another major aspect as far as these non-profit organizations or the NGOs are concerned. So as per the 2013 Act, Section 8 deals about formation of charitable company. Prior to 2013 Act, 1950 Companies Act 1956 was the law which actually governed the formation of companies, and there Section 25 was the company, or Section 25 companies was the provision which dealt about formation of a charitable company. I know that you may be having so many doubts, so let us make it as an interactive session. Whatever doubts you have, then and there itself you can ask it, or at the end of presentation, yes, we can obviously have a Q&A session. Now let us see what are the registration process of an FCRA. There are two kinds of FCRA registration. That is, as far as Form FC3A is for the purpose of registration of an FCRA license. Apart from FCRA registration, there is another set of requirement that is also known as Form FC3B, which deals about prior permission. So there is a slight difference between these two things. As for the FCRA Act, we can apply for two different things. If you want to get a proper registration, you can apply for an FCRA registration. Earlier, an FCRA registration was lifelong, that was the validity, but as per the 2010 Act, there is the certificate would be valid only for 5 years. Now, an FCRA registration, if you are getting, the validity would be for 5 years, and accordingly, you can renew it for another 5 years. That is what the present position. Secondly, the prior permission category, which means if you if an entity would like to get a one-time financial assistance from abroad, then you need to get only prior permission. You don't require to have an FCRA license at all, because your requirement is only to get a one-time money from abroad. So for that purpose, you need to get only a prior permission for getting a donation from abroad. And the entire thing for FCRA registration and its periodical regulation, its requirement, everything is happening through online. That website is known as www.fcraonline.nic.in. Now we cannot do anything on a manual basis. The entire thing, right from the submission of the application, and the entire thing would be governed as per the e-process, that is through the online portal only. The entire procedure would happen. There is no physical submission, or there is absolutely no possibility for any kind of physical communication with the FCRA department. Entire thing has to happen through online. I think most of the even in the Companies Act, or even now the Societies Registration Act, everything is happening through the e-mode. Now, what are the main purpose or activities for which FCRA can be obtained? This is actually a recent development. As per the June 22nd FCRA amendment rule, that again brought out with a restriction which states that the FCRA can be applied under major 5 categories such as religious, cultural, economic, educational and social. These are the 5 major heads, and again there is a sub-classification. That sub-classification would be around 105 items. You can obtain FCRA license only for these main areas. So the sub-classification is also there in the rule which is notified by the Ministry of Home Affairs recently, that is 22nd of June 2026. Now, what are the documents required for obtaining an FCRA license or a prior permission? It says that registration certificate or trust deed. A society or a charitable company is concerned, there are three documents basically. There is a registration certificate would be there. For a company, there is a certificate of incorporation. For a trust is concerned, there is only one document, that is a trust deed. That is the only document for a trust. And then for a society, there is a memorandum of association, rules and regulation. For companies, there is an articles association, and then rules and regulation. Then the list of governing body or the board of trustees. For a society or a charitable company, there are board of directors, and for a society, governing body members, and for a trust, it is board of trustees. So you need to provide the entire details of the present governing body, including their Aadhaar card, their PAN card, their address, the entire thing you need to provide. Then yes, the NGO Darpan. Now all the entities, all these societies, trust or charitable company, we need to have a registration with the NGO Darpan. That is even required even for maintaining a bank account. So NGO Darpan is actually it's a creation of the erstwhile Planning Commission. Now the Planning Commission has been abolished, and that was being notified as Niti Aayog. So the NGO Darpan is unique ID has to be obtained from the Niti Aayog. That is required for all the NGOs are concerned. Unique ID is a must, and even for the FCRA, unique ID is required. And then the income tax return and the activity reports for the last 3 years. These are actually required for the purpose of obtaining an FCRA license. Then what are the FCRA registration process? Yes, all the documents I have mentioned, and the FCRA portal that is also I have mentioned, and you need to apply it through online. And after submission, the IB, the Intelligence Bureau, will conduct a thorough inquiry on the entity, its activities, particulars of all members, even through the Indian missions abroad in case of NRI or OCI. Yes, as we are aware, the governing body members or the board of trustees or the directors, maybe they may be working in a foreign country. They may be two different major aspects of foreign, in the Indian origin people, those who are working in abroad. There are two major categories. One is an NRI. NRI means he's an Indian citizen, but he is working in a foreign country, or he is residing in a foreign country as per the Income Tax Act. That is what NRIs are concerned. A person who is residing in a foreign country for more than 181 days would be coming under the category of an NRI. And the OCI means overseas citizen of India. A person who migrated to a foreign country and obtained a citizenship of a foreign country, then naturally he can't be an Indian citizen. India doesn't recognize dual citizenship. So in that case, they are entitled to get the category of OCI, overseas citizens of India. So those people can also be part of these entities, and those entities can also apply for the FCRA registration. But then the only concern is that if the governing body members are NRIs or OCI card, then the inquiry of those persons will happen through the Indian missions. So that can take a lot of time. So if you are mentioning the details of your the governing body members, those who are in a foreign country, then this can take a lot of time for conducting the inquiry by the investigating authorities. IB persons, their presence may be largely restricted to India only, and if the people are in a foreign country, then those inquiry will happen through the Indian missions of that respective country, and that can take a lot of time. Well, generally, if you apply for an FCRA license, that the time duration for considering and processing of that application and either to get or a rejection, it may take around roughly around 6 months to 1 year. That is what the general time period. But if the members are from abroad, so getting an inquiry from in a foreign country, that can take even so many months. So that is one of the gray area which you may please keep it in mind. And then yes, it is a statistics which says that at present approximately 16,000 associations are registered under the Act, and they receive around 22,000 crore annually. Yes, this is what the data released by the Ministry of Home Affairs recently. And then again, the ministry always says that yes, we need to have a foolproof system to regulate the receipt of all the foreign contributions. We are all part of some companies in which you may be knowing about the utilization of CSR fund. There are many companies which are performing an excellent service by correctly utilizing the money for the purpose of charity. But there are so many entities which are only on the paper, and their charitable activity is also only on paper. There are equations such as 60, 40, 30, 70, all such things are there. So there also a lot of malpractices are there. So in FCRA also the similar things are there. Associations may receive huge fund for different purposes, and that fund can be utilized for so many other aspects, or the money can be misused, and all the mechanisms, all the new restrictions are actually brought out with a genuine purpose. That is what I feel. But still there are certain regulations which are really excessive, and those things which can be always challenged before the court of law, because right to form association is a fundamental right guaranteed by Article 19 of the Indian Constitution. Every citizen has a fundamental right to constitute or form associations. That's a fundamental right. So any kind of restrictions imposed by the government by way of unnecessary requirements or restrictions can always be challenged before the court of law, and the court can decide on all those aspects. I am specifically pointing out this aspect with regard to the recent proposed amendments. The March amendment, which was actually the government was actually stopped it. They are not proceeding further with that amendment because a lot of criticism were there from the civil society organizations. And the recent amendment which was notified last week, that is also, there are all the potentials to challenge those aspects before the court of law. Yes, this is what the new development which actually happened as per the Foreign Contribution Regulation Amendment Bill 2026. One of the major aspect with regard to this the recent bill is this is actually introduced, but it is actually deferred. This bill is not yet passed, and we don't know how the government is going to take up that matter further. The next monsoon session, somebody says that this can be again reintroduced sometime in the next month, but we don't know what is going to happen. But some of the provisions of the new bill are it's really drastic. The statements of objects and reasons, which again it's a kind of data which says about the kind of number and the kind of amount which actually coming to India. And one of the major changes proposed in the new legislation is creation of a designated authority to take over, manage or dispose of the assets created from the foreign fund when an NGO's FCRA registration is cancelled, surrendered or seized. This is a major aspect, because there are thousands of organizations which lost their FCRA registration recently. So the new bill says that if your FCRA license is seized, cancelled, or even surrendered, then your entire assets which actually created due to the foreign fund can be taken over by the government. That is actually a major aspect, because as I told, the FCRA Act was originally enacted in the year 1976. Even prior to that, there was no such legislation. But there are societies, there are so many environmental organizations, other literacy organizations or healthcare organizations, which were functioning even prior to the independence. There were organizations registered in India. They got foreign fund and they have created assets, and all such things. If the moment their FCRA license is cancelled, then the government can take over that asset. That's a major, it's a drastic kind of measure. And the other funny thing is that maybe I must have received 1,000 rupees from foreign country or a foreign contribution, and 99,000 or 1 lakh rupee must have been contributed from the domestic fund. So the I received only 1% of fund from the foreign country, and the 99% of the money is local contribution. But if the FCRA license is cancelled, your entire assets can be taken over by the government. That is what the language applied by this new bill, and that is one of the major reasons by all the civil society organizations were criticizing the government's move, and they have ultimately deferred that bill for the time being, and we don't know how is it going to develop further. And please note that all the government time and again came out with different kinds of restrictions or the legislation. Even during 2010, major amendments were brought out by the then government, and then in 2020 again there were major amendments were brought out at the then government. Those things were challenged before the various High Court and the Supreme Court. Some of the amendments were actually upheld by the Supreme Court, and one of the major judgment passed by the Supreme Court in 2022, which is known as Noel Harper versus Union of India. In that landmark judgment, Supreme Court has observed one aspect, saying that now India is a developing country, or it's on the process of a developed country, and we need not depend much on the foreign contribution as such, because we can generate domestic fund from our country itself. And then in that particular judgment, they have upheld some of the changes brought out by 2020 legislation, which actually restricted the utilization of some of the administrative expense. That was the administrative expense which an entity can be used for the FCRA fund was reduced from 50% to 20%. That was one of the major restrictions brought out by the 2020 Act. And also the 2020 legislation, which again state that all the entities should have a central bank account at SBI New Delhi, and all the foreign fund originally has to be credited in that centralized bank account, and accordingly after the scrutiny that money can be forwarded to the utilization account at the respective place. So that was an amendment brought out by 2020, but unfortunately the Supreme Court has upheld both the amendments, and the only thing is that this actually created some inconvenience, but otherwise the entities which are following proper financial and legal compliances, they could survive without having any problem. So my humble submission with regard to all these aspects is that we should know what are the developments, what are the new changes which are actually brought out by the government, and we need to fulfill all the requirements meticulously. Otherwise, this can lead towards cancellation of your FCRA account, and once it is cancelled, the assets can be taken over by the government if that the bill is going to be approved as an act. Yes, vesting of assets already I have mentioned, and then the mixing of fund, local and foreign contribution. So you need to, if any of the organization which actually receive foreign fund, then you should have a separate accounts and separate aspect also as far as your assets are concerned. Whatever assets which you are creating with your domestic fund, don't mix up with both fund, local fund and the foreign fund, because suppose something happened in future, your entire assets can be in trouble. Yes, now the new legislation or the new bill which actually expanded the definition of key functionary. In FCRA, generally there is a key functionary. He is the authorized person to sign all the documents. That is what the key functionary is all about. But the new legislation which says that not only the key functionary, all the governing body members are liable for any kind of fraudulent activities. So that is what the new bill says about the expansion of key functionary. Yes, and then prior approval from the central government is required for initiating any kind of inquiry. If there are any fraud committed by an entity at a local level, earlier the state government or the state local authorities can also order for some kind of investigation, but now the entire power is vested with the central government. Only with the approval of the central government an inquiry or an investigation can be initiated. And then restriction during the suspension. Yes, earlier there was a provision for withdrawing money even during the suspension period by applying to the FCRA department, but now that also has been restricted by this new amendment. Yes, these are the way forward. If you are so keen about our civil society and the strengthening of the civil society movement, then obviously public pressure is required, and that is exactly happened. And on the public pressure only, the government actually withdrew from the bill recently introduced, and then following financial and legal compliances. That is very, very, very important. We should be aware about what are the changes, what are the new areas of changes. There are two major aspects. Legal compliances are there, financial compliances are there. We need to have a proper professional to advise us on complying with the new aspects. That is very, very important. And obviously the legal recourse. If suppose some of the organizations lose their FCRA license, please don't keep quiet. You need to take it up further, because if you are accepting the cancellation of your FCRA, then the danger is there. If your FCRA is cancelled, tomorrow the government can come up and they can take over your assets. So wherever the association who actually enjoying an FCRA license, and if the government pointing out some of the deficiencies and taking any coercive steps such as suspension or cancellation, then you need to take it up further. You need to take the legal steps, because if you are right, if you are following all the required instructions and the rules and regulation, then obviously you can take it up further. The people may be having a tendency stating that if we are going to the court, then we are fighting against the government. Then the government can trouble us by applying so many other things. So there is an apprehension among the civil society or the citizens. But please note that you need not have such a fear, because moving to the court or protecting your fundamental rights is your right. That is guaranteed by the Constitution. You need not worry about that. So wherever your license is cancelled or suspended, then you need to take it up further. You need to apply the legal recourse so that you can correct the action applied or enforced by the appropriate authorities. Yes. It's over. Please.
Yes, we'll have a few questions, please.
Yes. Then it's fine.
evening. Does Article 19 actually protect you from getting funds?
Straight away, can I answer?
Yeah.
Article 19 talks about your right to form association.
Yeah.
Only limited to that. Getting funds,
Absolutely.
even the Noel Harper Supreme Court says that
Absolutely,
you have no
absolutely,
fundamental
absolutely.
right. Yes.
That was my understanding. That
Right.
Number two is, even for funds which have come to India before 1976, when this act was particularly not in effect at all, those assets which have been created by that fund, will it be affected by this?
Yes.
I understood that it would be.
Yes, that is what the tricky aspects. Now, during the last so many years, the FCRA department frequently asking all the associations for the informations with regard to the assets which are created using the foreign fund earlier. So there was a data mining happening during the last so many years. People were not aware for what purpose the government or the department was asking all this information. Some of the persons mentioned so many things. They thought that I can create a goodwill by saying that we have so many land, lot of infrastructure, so the government can support us. In such a way, people provided all the information. Now all of them are going to be in trouble.
But actually that is a very, very dangerous grave digging.
Absolutely, absolutely. Yes.
Okay. Number three was, what does the designated authority do with the acquired properties? What he can do, or what that particular organization can do, number one.
Yes.
Number two, if I have a trust which has got money from outside, I am running an engineering college, for example. I'm not running. Okay. So if I have been running for 20 years, I got some money from some foreign investor, not investor, but foreign charity organization. I built one part of my electrical lab with that. And the entire other blocks have been created by my own, or rather domestic charity. Then what he can do with this, or how I can function?
Yes. The first aspect is that the vested authority, that vesting authority, that is yet to be defined. Okay. Only the act which says that if the FCRA license is cancelled or suspended or seized, then the assets can be taken over by the vesting authority.
And who is that authority?
That central government will notify. Okay. So the appropriate rules are yet to come. Okay. Only the act only says about only this much, and all the other clarity would come once the government notifies the rules. The rules are yet to be notified as far as the vesting authority is concerned. But the earlier act also says about the vesting, which includes the government can take over, and then they can transfer that assets or that entities created using foreign fund can be transferred to similarly placed organization. That is what roughly says, but the major aspects are yet to be clarified.
I am hitting at the right point.
Yes.
So the trust can be dispossessed.
Absolutely. Absolutely. Yes.
Good evening.
Good evening.
I'm an ex-banker. I have two questions. One, is getting an FCRA registration, whether it has been society or any entity, very, very cumbersome, very, very challenging. Probably if you are going directly through that, consultants for MHA also, will take a few months or year plus. The revised, which we have been, now came out, is there any process given for easing out that process for new registration? Or is there any single window is created for this? That is a question number one.
Yes.
Question number two. See, NGO, we have mentioned that there is an 50% of donation amount can be used for administrative expenses. Actually, this is the area previously. I'll come back to that. 50% was, NGO can use it for administrative expenses. This is a gray area. NGOs are misusing that area. Now this is brought down to 20%. So here, this is only for NGO or for other entities also. Then, if that is the case, issue was now what happened, I think few years back, government restricted for that auditing for that NGOs. That were all donations stopped, almost stopped. So few of the, few of the NGOs almost closed huge number of NGOs in India is closed because of these restrictions. And in their under lens also, legal lens also. Here, if in these other entities, all these donations received by entities, those of doing that profit-making business, example, not NGOs with profit making, there is a separate entity. What would be that tax implication for them?
Yes, the first aspect is with regard to the a single window or any such things are actually created by the new bill or the new rules. That is what the first question. Please note that if we analyze the mood of the government for the last 10, 20 years, they are not so encouraging with the NGOs for getting foreign fund. And that is so evident by analyzing all the new restrictions or the new bill, new legislations, new rules, which are actually to regulate or excessive control that they are applying. That is for the purpose of regulating these entities. And in these entities, there are, you may be, or we all know that the government may be having their own viewpoints on certain aspects. Now, the present dispensation is very much angry about some of the aspects such as conversion. Let us be very frank enough. Some of the areas, the conversion is happening. That's a fact. And the government want to restrict it. And the NGOs which are actually attached with such functions are concerned, the government is not at all encouraging for those kind of entities. Or similarly, some of the environmental movements are also concerned. Government is not so happy about those sector. So in those areas, government actually bringing or making a lot of restrictions. And here, a person applied or an entity applied for an FCRA registration, government can reject it without assigning any reasons. So that is what the wide power which actually the government is having. They can reject an application without assigning any reason. That is one aspect. But an association which actually having an FCRA license, if that is cancelled, the reasons has to be mentioned, and that reasons can be even challenged before the court. But initial application can be rejected without assigning any reason. That is one aspect. And your second part of the question is related to the cap of or reducing from 50% to 20% with regard to the administrative expense. Now, that was a welcome change in my opinion, because foreign contribution may be to the tune of 100 crore may be received for a specific purpose of creating educational institution. Maybe 100 crore must have been received an entity. And if suppose they are spending 50 crore for the purpose of litigation charge, is that permitted? So such kind of fund diversion were actually there by citing some administrative purpose such as salaries or those kind of things were mentioned by the entities, and there was a tendency of diversion of fund. To reduce such thing, the government introduced the reduction of administrative expense. Administrative expense means paying salary, paying electricity, paying rent. These are some of the things are actually coming under the definition of administrative expense. Administrative expense is only for the purpose of carrying out that particular objective. The main objective of that foreign fund is for performing certain duties. So that cannot be diverted by spending huge money on the administrative expense. So that was the reason by which the government brought out with an amendment in 2020 by which the administrative expense has been capped from 50 to 20. And these things are applicable only for the FCRA registered associations. We have so many other societies and trusts which are actually functioning with the ATG 12-way registration. There is absolutely no restriction regarding this 20% of capping. That is there only for the FCRA registered organizations.
If that is the case, NGOs with trust with the profit making, there is another type of we can do. There are other societies also where we are just there is no there is a restriction of 20% for that also, right?
May I clarify that an entity such as a society or a trust, they can't. They are non-profit organization. They can't generate the income generation also. Suppose if a trust can have some property and they can give it to lease or rent and they can get some income. but that money cannot be utilized or that cannot be shared as a profit. That is absolutely not permitted. That is what one of the fundamental difference between a non-profit organization and a for-profit organization. All the other management or the companies, except charitable company, they are actually, their objective is to make profit. So it is applicable for the profitable organization, but all the society, trust and a charitable company, their primary objective is to do charity.
So there is no tax implication, you're saying?
For tax implication, if you have an 12-way registration, then there is no tax implication. In the absence of a 12-way registration, if your income is beyond the threshold, then you need to pay income tax. Yes.
Yeah. Okay, thank you.
Yes.
Hello. Yeah. Recent past, we have seen a trend actually, Chikilsa Sahayam. Okay, patient help, they put some video, give that patient bank account and say that we are going to get around 10 lakhs or 15 lakhs or 20 lakhs. But we see that within 1 or 2 days, they get a huge amount, maybe a crore amount, and they say, ask this patient to pay back to them, actually for giving for some other patients. That's what statement they make. Are you seeing anything inappropriate in this kind of act?
Yes, you are talking about crowdfunding.
Yeah.
Yes, it is there. Now there are so many self-proclaimed mishras are coming all of a sudden. They are placing some videos saying that there is a patient suffering from this disease. Kindly donate money. And in such scenario, the large chunk of money is coming from abroad, but they are Pravasis, our own persons only. So Pravasis, generally, by default, they are Indian citizens. So if they are sending money from their own NRI bank account, there is no question of any FCRA as such. Because the foreigners are not donating money generally. But if a foreigner is donating money in that particular person's account, FCRA would be applicable, because that is not permitted. Without having a registration, OCI can be, this can be, because they are part of, absolutely. OCIs and NRIs, and the money can be, they can send to their relatives, absolutely no problem. If my brother or somebody, my relative is there in a foreign country, I can get the money. That is actually exempted as per the FCRA Act. But there also there is a requirement, there is a form FC3, FC3C. As per that, you need to intimate the government, saying that I am in receipt of certain amount or this much of amount from the foreign source.
That is applicable for OCI, but not for NRIs.
No. This Indian origin can be, this can be. OCIs and NRIs, that is applicable. But only the other foreigners, it is not permitted. Yes.
Anyway, thank you, Aljes. The way you have introduced and the way you have presented the case has been excellent. In fact, some of us, I think, we came with no knowledge on this. But then we were remembering the time when during the elections, when this was introduced, there was so much of halla that FCRA is going to affect us. In fact, even in Kerala also. So by creating a scene, won't it attract the attention of the government? For example, I will not say that it's church, but then some of these organizations were really, troubled by this FCRA. But then won't it, just as you told that the government is always watching, then some of the people had gone overboard by stating that these were the things which we have done, these were the money which we got. So that way, in what way the government is studying it? Is it the bureaucrats which is formulating these things, or is it the politicians who are doing that? I'm not talking of any dispensation before that, and because from what I gather is that in 75 also this has happened. It was a Indian National Congress government. Then down in 2010.
Yes.
Yeah. Again, it was Indian National Congress, and now, of course, it's a BJP dispensation. So, obviously, who exactly, winds up these politicians to take up this course of action? I mean, is it the Intelligence Bureau, or, as a legal luminary, what is your assessment of the situation?
all these civil society movements are generally creating trouble to the government, whoever is in power. So all the NGOs are actually strengthening the or the grassroots level organizations, and mainly they are their agenda or their activities may many a times goes against the establishment, whoever is in power. So that is one of the reasons by which in 1977 the then Indira Gandhi government, they were really apprehending the influence of the foreign fund, and that can trouble those government at that point of time. That is how firstly this act was introduced. Absolutely, absolutely. Now in 2010, there was a lot of environmental movements were happened, even in our the Kudamkulam and such areas. There were a lot of agitation against various kind of developmental activities. So the government thought that we need to restrict the organizations which are actually promoting or the national interest is getting compromised, and that was again one of the reasons by which the then government brought out with certain restrictions, and that again continued in 2020 and 2026. The government, they have their own intelligence, their own inputs, and they know which area is needed to be addressed or which area needed to be controlled, and that is how the appropriate rules or the legislations are actually happening.
Thank you very much. So lovely discussion, and everybody were entrenched in whatever you were saying. I request Dr. Radha Tevanur, our co-chair and chairperson of Women Managers Forum, to come and please hand over a memento to the speaker.
Thank you, sir, for that highly enlightening and
I have authored a book on the FCRA Act, and I am happy to give one complimentary copy to the President of Kerala Management Association. Thank you.
Thank you, sir. As we come towards the conclusion of this evening, I invite Mr. Ramesh Nair, Joint Secretary, Kerala Management Association, to deliver the vote of thanks.
President of KMA, Sri Algiers Khalid, Program Chair, Dr. Anil, and today's keynote speaker, Dr. Joseph Ram, our distinguished guests, members of the management committee, all of you, very warm good evening. So you've all been enthralled by a session of FCRA, which is a really hot topic, and we've been speculating about, the media has been speculating before elections and post elections, what is the outcome. So we got a glimpse of what actually it is. From the very clear narrative, he could bring in some clarity on, even though we are not sure of the specifics, how it is going to come. But we all understand one thing, it is very serious things, because anything can happen if things are not done the right way. But I'm sure that government will have, take cognizance of all the opinions, public opinions, and will have the middle path or whatever is the best in the interest of society and country. So again, it was a thank you, Dr. Joseph Ram, for the fascinating session. And I hope with the questions that we could see that everybody enjoyed. I hope you agree with me. So it was a good session. And thank you, Dr. Anil, for having such a wonderful program. One more program. So thank you. And again, thanks all of you for being here and attending and being actively participating, and the MC and secretarial staff, all of you, a very big thanks from me and the KMA, and we look forward to having you here for the next week. We have another a gig session. It is by Dr. Anjana. It is about the what is happening in the industry now, especially in the employment front, where the jobs are not like the traditional jobs. It is gig jobs, what we call, like the typical Swiggy, that kind of Flipkart kind of jobs. So that is the need of the. We need to have more understanding, all of us, including me. So let us be prepared for that. So thanks once again, and thank you all. Thank you.
Thank you, sir. Now, I request everyone